It pops up.
Hello, everyone. It's Lisa Patterson with Daniel Ravenel Sotheby's International Realty in beautiful Charleston, South Carolina. And I'm here with Jennifer from Case Law again. And today we are going to talk about the roles of the buyer's closing attorney and the seller's closing attorney. I know people don't buy a house every day, Jennifer, so they get really confused sometimes. Even people that's done it a few times get a little confused of who's doing what. So tell us a little bit. And then the other question I want to talk about is a lot of people say, what if everyone uses the same closing attorney? I don't advise that, but I'd like you to talk a little bit about that as well. So.
Okay. Yeah, that sounds great. Thanks, Lisa. So, yeah, I'll talk about the using the same attorney. I first want to talk about the different roles that parties have in the transaction. So we have, South Carolina is an attorney state. So each party does have to have an attorney representing them. So the buyer needs to have an attorney. The seller needs to have an attorney. The roles are different with those two different parties as they would be because the buyer is buying and the seller is selling. So if you're the buyer's attorney, you are the settlement attorney. You are the escrow agent for funds from the lender, from the buyer. You are the person who disperses everything. You're the person who acts as the liaison between everyone in the transaction, the buyer, the seller's attorney, the lender, insurance company, termite, everything is going to come through you as the buyer's attorney. All funds are going to come to you. You will be dispersing the funds. And so that's important for sellers to understand that if they have their own attorney, that attorney is not going to be sending their wire. That their attorney will not be sending the payoffs. That will be done by the buyer's attorney. So it is important for your attorney as the seller to make sure they stay in communication with the buyer's attorney. They're aware of, when closing is happening, when wires will be sent, so they can keep their client updated. But if you are, so the buyer's attorney really is the settlement attorney. They're the ones who kind of do the bulk of the transaction with the money prior to and after closing. The seller's attorney, alternatively, represents the seller and prepares documents to be signed by the seller. Oftentimes, the seller can sign in advance of settlement, which is perfectly acceptable. And the seller would sign with their own attorney, separate from the buyer, separate from the buyer's attorney. And this is probably the trend down here. I would say most sellers have their own attorneys. Most sellers sign prior to closing. And then everything is sent over to the buyer's attorney. So it's ready in there once closing actually happens. It doesn't have to. It can close the day of and documents can be couriered over. That's fine too. But I would say more and more I'm seeing sellers just for scheduling purposes and ease get everything done beforehand. So the seller's attorney, drafts the deed, which is the conveyance document, drafts all of the additional documents for the transaction. What the seller does not do is draft the settlement statement, which has all of the figures and numbers and fees on there. That is done by the buyer's attorney, by the closing attorney. So that comes from them. So if the seller does sign early, it's just important if you are the seller to understand that you may not have that final settlement statement at the time that you are signing, particularly if you're signing several days in advance, because that's not going to come from your attorney. That will come from the buyer's attorney, and that will be emailed or sent out to you, however you work that out with your attorney prior to closing. And so as far as using the same attorney, it's allowed. You can do it. I have seen too many cases where issues arise and it's very difficult for the attorney to represent effectively both parties when issues arise. And I've certainly seen it where there's no issues and it's smooth and it all works out. But I've seen it enough times where there are issues that my advice to a buyer and a seller is to get separate attorneys. It works out better, in my opinion, overall. So I would certainly suggest to get different attorneys. I would advise against using the same attorney. Even if it seems like it'll be easy, even if it seems like nothing will go wrong, you just never know. And so it's important, I think, for each party to have their own representation, to look out for their interests, because they have different interests, as we've talked about in prior episodes regarding the contract. You know, each party has kind of different goals that they're trying to reach. And so I do think that having a separate attorney is preferable. And so, you know, once everything is signed with the seller's attorney, it gets over to the buyer's attorney, the buyer signs with their client, with the purchaser, and then disbursements are made. Wires are sent out and checks are sent out, and all of that is done by the buyer's attorney, and everything is closed after everyone signs. And so, and recorded. Recordings are also delivered to the courthouse by the buyer's attorney. So also important to note, even though you sign the deed with your attorney, that is going to be transferred to the court, recorded by the buyer's attorney. I think it's important for sellers particularly to understand just kind of what role their attorney has, and they're not the ones sending out the wire. They're not the ones getting everything on record. They sign with you and get it all over to the closing attorney, which is the buyer's attorney. I mean, that's pretty much the process and the differences between the two attorneys. I did want to, Lisa, did you have anything to add before? I wanted to also kind of touch on the closing process in general prior to closing. But did you have anything to add about the roles of the attorneys?
No, I think that's the biggest confusion is who's sending the money. I think
yeah,
now the seller's always thinking, you know, where's the money when I represent the seller? And I have to tell them, you know, especially if I'm not representing the buyer, I have no idea what is actually going on with that attorney. Very little communication. What happens, we usually as the agent get an email from both. They only ask us a few questions. You know, what's the commission splits? How do we want that sent? Are we picking it up? Is it going to check to our office? But other than that, that's about all we have. I do attend closings with my clients unless the other thing I did want to mention when I don't attend is because no one attends closing and they have a power of attorney. Mm-hmm. And you might want to touch on, you know, you need to get that in advance. That can't be a last minute thing.
Yeah, no, that's a great point. You know, to talk about different ways you can close, especially nowadays, right? So, you know, typically we have a closing event where, and oftentimes, as I mentioned before, the seller has already signed with their attorney. So most of the time when I'm representing the buyer, we do have a closing event with the buyer. The buyer comes in and they sign everything. The agent comes in and we do all of our signing. And after the buyer signs and we've received all of the funds, you know, it's closed and everything's closed. That's typically how we do it. However, nowadays we are seeing a lot more alternative ways to close. And there are really two alternative ways to close that I'd like to maybe just let people know about. One, of course, is the power of attorney. If you are a buyer and you want to sign by power of attorney, I need to know like day one that you need to do that, because the process, if you have I will clarify that. If you have a lender, if you are using a lender, I need to know as soon as possible that you as a buyer want to use a power of attorney, because that power of attorney has to go through lots of different chains of command at your lender, with your lender, and they have to ultimately approve the power of attorney. And oftentimes they have edits that need to be made, changes that they require before it can be sent out to the buyer for signature. And so that's why the earlier the better. So I can get that out, get that approved. And then once it's signed, it has to go back to the bank for their final approval. So it's just a long process with powers of attorney. The other issue, if you are a buyer and you have a lender with signing of a power of attorney, they have very limited, I mean, it really depends on the bank, but most banks have very limited people who can sign on behalf of the borrower. And that includes those people who are specifically not allowed to sign include me, the closing attorney, anyone in my office, you, the agent, anyone affiliated with your brokerage, and anyone affiliated with a lender. So that right there, you know, particularly if you're out of town, out of state, those might be the only people that you've dealt with, you, me, and your lender. And so it becomes an issue as to who's going to sign for the power of attorney that will be approved by the lender. So, you know, and I can talk to buyers about different options and all of that. And obviously that can be a case by case basis, but the bottom line is it's a long process. And the person who, and it is important as a buyer that the person who signs cannot be me, cannot be you. It cannot be anybody connected to the transaction at all. It's got to be somebody completely separate. And a lot of lenders have even more restrictions about that it can't be, a stranger, that it has to be someone related, closely related to the person. So it's becoming a little difficult with some lenders to sign by power of attorney. But most of the time it's still fine as long as we know in advance and as long as we can get everything set up as early as possible. The other option with a buyer's is a mail away closing. And so this is a little more, I would say it puts a lot more on the buyer. So we would need to send them all of the documents, which, in a purchase transaction could be 150 pages.
Yeah.
So we would have to send the entire package to them with everything that has to be signed and notarized. They would have to go out and find a notary, as well as an additional witness for a couple of the documents that require an additional witness, and get all of that signed by themselves. And obviously I'm available during the closing time when they go and do it by phone or FaceTime or Zoom or however they want to communicate with me to make sure that they understand what they're signing and they're signing it properly. But it's on them to find the notary, which is just kind of, difficult, particularly in these times. So I would say the power of attorney is probably easier as long as we know it in advance, but a mail away is also an option. And I have had several borrowers prefer the mail away, and will just sign remotely.
Okay.
So yeah, those are the two options for buyers if you don't or want to or unable to for an actual closing.
Yeah, that's and I have a lot of closings that happen with the power of attorney. A lot of the
Mm-hmm.
people that buy with second homes and they're not here, and we do everything up front. So,
And if you're a seller, real quick, if you are a seller and you're selling, I can act as your power of attorney,
right.
and I'm happy to. But that's much easier. If you're selling, there's no lender involved. I will act as your power of attorney. I can sign everything for you. It's a very, very easy process. So I have oftentimes sellers who think they're going to make it, but they can't, and I can get them a power of attorney, executed and turned around fairly quickly. If you're buying and you have a lender, it's going to be a longer process.
Right. Okay. Anything else you want to add?
Not about that. I did want to talk about, for buyers, the closing process. I just wanted to maybe explain to them, because I know when you're buying a home, you primarily, if you have a lender, that's who you're primarily working with. They're emailing you every day, every other day, asking you to send you this documentation or send you that documentation, and send it five or six times. It's a very taxing process to buy a home, because there's so many requirements that the lender has. So they can't get around them. And so they do have to make many requests for documentation. So it is a lot. So the buyer, understandably is kind of wrapped up in that world and getting everything they need to the lender. And they don't see the whole process. And so it is important to understand that, while they're doing that, we as a settlement agent, closing attorney, are working with their lender. We're working with their insurance company, with the agents for termite, for repairs, for home warranty. We're collecting all of that stuff, on the back end to make sure, and we're obviously doing title search, making sure title's clear, clearing title if we need to. So we do all of that, simultaneously during the closing process, during the period of time between contract ratification and closing. What I think is important for them to for buyers to understand is at the time, so let's say closing is scheduled for, what's today, tomorrow, May 9th, okay? So closing is scheduled for May 9th. It is likely, and there's a lender involved, it is likely we would not receive instructions from the lender until today. And when I say instructions, I mean all of their fees, and the bulk of the buyer's closing costs are going to be lender fees. And so they don't send that to us typically until the day before closing is when we get all of their figures. And so once we get those, we input them into our system, and we have, all the additional fees that are not going to be on their closing disclosure. And that's going to be, tax prorations, HOA would typically not ever be on there. And some other miscellaneous costs may not be on there. So a lot of stuff is not going to be on those instructions that they send us. Once we get that, we put everything on there, send it back to them. They review it. They send it back to us with some tweaks. And this process can last hours. The going back and forth between the closing attorney and the lender to finalize the closing statement. And so it's just important for buyers to understand, because I know buyers are always very the wire out or to go get their certified check or, to get their funds. But just understand kind of that we can't get that final number out until we get that final approval from the lender, which is typically not going to be until the day before closing. And they always say, well, I got my closing disclosure 3 days before closing, which is true. The lender is required to get that out, but it's not final.
Right.
That is not the final number. It's going to be missing numbers that the bank doesn't have. It's going to be missing HOA. It's going to be missing maybe some invoices that we received, the bank doesn't have yet. It's going to be missing oftentimes tax prorations. There's a lot of stuff missing that it's not going to be the final number. And so it's important for buyers to understand when you get that closing disclosure that's required to be sent to you 3 days before closing, that is not the final number. Don't rush to the bank to wire it. That has to come from your attorney. That final number has to come from your attorney because the attorney is working with the bank to finalize that number. And once the attorney gets that, green light from the bank, then we send it out, which unfortunately oftentimes is the day before or even the day of closing. It really just depends on.
Sometimes the day of closing. I've personally had transactions myself where I'm hours before closing waiting.
Oh, yeah. It is. And it is, and unfortunately, it's just not unusual. And at the end of the day, I really don't think it's the bank's fault. I think it's just the nature of the beast, and I think it's the way that it's structured. But yeah, it is frustrating, and I do understand that from the buyers. And what I always tell buyers is that if you do need to get to the bank early, or you do need to go ahead and get those funds out, you can use the closing disclosure that was sent to you, but I would tack on a little bit of a cushion on there, and then we'll refund any excess money out. But I would wire a little bit over because that's always going to change.
With you talking about fees, and this I get this a lot from clients, sellers, and buyers. They will ask when they're picking their closing attorney, well, what do they charge? I know I've had it happen before. Buyers call around to multiple closing attorneys and ask, and they get a fee back. And I know with you, Jennifer, you've quoted for some of my buyers before, but the thing they also need to know is when they get that quote sometime from other closing attorneys, they don't realize there's all these other little things that can be tacked on. I know your office does not do that, but can you talk a little bit about that?
Yeah. So with fees, I mean, my experience truthfully is in this area, for the most part, most closing attorney fees are pretty comparable. I mean, you may be talking about like a $25 or $50 difference, but my experience is they're all pretty comparable because we all work, we're all in the same business, and it's we don't. There really isn't. I mean, you may find one or two that really have low fees. Maybe they don't do real estate, but those of us who primarily do real estate, and this is our business, our fees are about the same, truthfully. And again, I mean, maybe $25, $50 difference, but if you do get it, and sometimes the fees are allocated differently, as you mentioned, sometimes they're all in the attorney fee. So, the attorney fee seems really high. Sometimes they're mostly in the attorney fees, but then there's all these other little piddly fees that are added, and not piddly. I mean, just additional fees that are added. And so there are, I would say at the end of the day, the fee, what I would tell buyers and sellers is that the fees are about the same with the attorneys. I would not, and again, if they're not hundreds of dollars difference for the most part. There may be $50 difference, but what I would tell buyers and sellers is I would not choose my closing attorney based on the fee because they're just too close, really. And you're right. I mean, if a buyer quotes and a buyer's attorney says my fee is $250, I can almost guarantee you that there are other fees collected.
I've had buyers that's happened to because I usually get a list of people. I can say, I've said it before about Jennifer. When you're dealing with Jennifer's office, you're dealing with Jennifer. You're not dealing with the paralegal. You're not dealing with all these other assistants and things. You have her cell number. You can call her, ask her questions. And it kind of goes back to, even though the fees are pretty close together in this area, as you said, I'm a firm believer you get what you pay for. I don't care what you're doing, so that it makes a big difference. And I have had closings with people that have picked based on that, and they've been, no follow-up, follow through, can't get information.
Yeah, I would say that the times that I've seen very low fees are typically from firms that don't primarily do real estate. So they just may not be as knowledgeable about real estate, which, as you and I have talked about, is very important in this business. You need to know your trade. And otherwise, I think the fees are pretty comparable. So I would not choose based on that. If they don't seem comparable, there are probably hidden fees somewhere you're going to pay. And so, yeah, I would take the advice of your agent, or make your due diligence, call around. I'm always happy to talk to any potential client. I do that all the time. Someone's just interested and they want to know fees, of course, but they want to know some other things. They ask some other questions for me. I'm always happy to talk to any potential client, buyer or seller, to talk to them about, the process or any questions they may have or anything like that. I'm always happy to do that.
Great. Anything else you want to add?
I think that's it. I think, I think we've covered the main points. I wanted buyers to understand about the process of getting their final number that they owe. I wanted sellers to understand that their attorney, which should be a separate attorney from the buyer's attorney, does not wire the money. I think that's important.
I think that's the biggest question.
Yeah, it is. And I wanted them to understand that. And I wanted to, people to understand kind of the different roles in attorneys, and that everybody should get their own attorney. I think that's the best course of action.
And there's one thing I want to add is, like you said, the buyers, especially, they're working through this with their bank, their lender, they're being bombarded with information they need. And then I, at the same time, am sending them additional documents, after you get the house under contract. That's just when it starts. There's all kind of things going on in the back end, and inspections and termite inspections and home inspections, and then, different addendums based on what we're doing, and credits or anything like that. So they need to get those documents back to me as soon as I get them to them, because in turn, I'm sending them to their closing attorney so that you guys have it to figure everything else out on the backside.
Yeah. And that's a good point. And I know, it's just good to know as a buyer, if you are buying, you need to be pretty much on your email all the time. You need to be aware, because everything nowadays is email, and you need to be on your email because, everything's important. I mean, the lender's asking for stuff that they need ASAP. You're asking for stuff that you need ASAP. We're asking for stuff that we need ASAP. I mean, everything, because we're all on a clock, and closing times are not, ridiculously long. I mean, usually you're closing within a month and a half. I mean, so we it's fast moving, which is why I love it. I love the fast pace, but we do like buyers particularly, because I know they're just overwhelmed with so much stuff coming to them, but that we do need that information. Sellers too. Sellers get stuff from us as well, and I know they get stuff from you, and we all need that back, ASAP as well. So it's very important, if you are buying or selling, to really monitor your emails and respond as soon as you can to get those documents back to us, because we're not just sending them for fun. Those are things that we really do need.
Yeah. And the other thing I want to add, because I see this all the time with buyers, sellers, other agents, we don't just put dates and times on those contracts of expiration of things just for the fun of it. That is a hard expiration of what's happening. We send an addendum over, it expires this date and this time. So
you're bound by that.
Yeah. All right.
Yeah.
Sounds good, Jennifer. Thanks so much for doing this again. And I'll talk to you soon.
Thanks, Lisa. Sounds good.
Thanks.
All right.